Legal due diligence is its own list, which we prepare and we adjust based on the business and the industry, the transaction. And really, what we're trying to do is uncover all the skeletons.
Welcome to a new wave of entrepreneurship by Venture for Canada. Venture for Canada is a national charity on a mission to foster the entrepreneurial skills and mindsets of young Canadians. Our vision is a Canada where young people can equitably realize their entrepreneurial potential to help build one of the most prosperous entrepreneurial ecosystems in the world.
Hello, and welcome to a new wave of entrepreneurship. I am really excited to have Josh Calderon on our episode today. He is the founder of Grid & Co. Law and an expert in entrepreneurship through acquisition, which is a big focus here at Venture for Canada. Josh works with tons of searchers across the country, helping them to acquire businesses. Josh, thank you so much for coming on the podcast.
Oh, thanks so much, Scott.
To get things kicked off, Josh, what are some of the key legal considerations every searcher should know before starting their entrepreneurship through acquisition journey?
Yeah, great question to start us off, Scott. I'd say the main thing is going into any potential transaction is knowing that every deal, every transaction has risks. There is no perfect deal. I've never seen one in my entire career. There's always going to be things that a searcher should be aware of. And that's really where the opportunity is, because businesses have these issues. And so everyone should know that their transaction will have issues. They inevitably come up, and it's just a question of working through them and making a decision as to whether any of those rise to the level of pulling the cord on the deal and moving on to the next opportunity.
I've noticed a lot of brokers and ETA investors often use the analogy of hair, and to say like all deals have like some kind of hair on them. And if you're going to buy a business, you have to be okay that there's going to be some, flaws. No, as you mentioned, there is no perfect deal. One thing I'd love to zoom in on is like, when should a searcher engage legal counsel for advice? So yeah, what is like the right time in sort of the deal process to engage an attorney?
Yeah, I would say as early as possible. And I think that it comes down to also like lawyers and people in the ecosystem. We can provide value that's not necessarily the value that like of our technical skill. So for example, searchers come to me. Often they think they need a signed LOI before they contact a lawyer. I think a lot of times because they're scared of legal fees. To be honest with you, I think that lawyers as a profession, we haven't done a good job of letting potential clients and clients know that we're available to be here as a resource before any sort of paid engagement. So early in the process, the better. To talk through maybe a potential deal that a searcher is looking at, as well as connecting that searcher with anyone in our network who could be helpful, whether a broker, whether a lender, whether a potential investor. I think building those relationships early on with as much time as possible is the way to go. And I think engaging lawyers who are in the space early in the process, where the ones who don't want to nickel and dime you for every conversation, every email. I think that if you find someone like that, the earlier the better, so that we can do our best job advising you.
One thing to double click on is like how early? Like, is it something where someone's gotten like a sim and then they send it off to the lawyer for feedback? Yeah, I'd love a little bit more additional clarification.
Literally, Scott, I'm glad you asked. Literally, I have searchers who haven't even started searching yet, and they've already contacted me to say, hey, I know we don't have an established relationship yet. There is no engagement letter. They have not engaged Grid & Co. But you are on our list of people that we might want to partner with as our legal advisor. And if you happen to reach, and they gave me their investment criteria, this is what we're looking for geographically, EBITDA-wise, industry-wise. And if you could let us know of any opportunities that you come across that might meet our criteria, let us know. And I think to me, that's ideal. Before they've even started searching, now I know who they are, a little bit about their profiles, and now I can keep my radar open for things that might be of interest to them.
That's a great example. How often do you find that you play a role in kind of facilitating kind of deals to sellers?
All the time. Not Rarely, I'd say, like introducing buyer and seller. It does happen, but in other ways as well. So there's that way, introducing buyer and seller, but also introducing a searcher to a lending partner or an equity partner, right? If they don't have the necessary financing to get a deal done, and they need to start collecting potential partners, um, it's the benefit of being part of the system and knowing repeat players, is knowing who do I know that could be a fit to provide this person with value, whether that's a lending contact, an investor contact, an accounting contact, a broker contact. So in those ways, to answer your question directly, um, a deal is really like a constellation of different people coming together, and and I, it may not be the central buyer seller relationship that we facilitate on, but often like some of these other relationships on the periphery that we help facilitate.
When it goes to the point you were mentioning earlier,
Mm.
which is that a lawyer is like so much more than just like a lawyer. Like a really effective lawyer is like a business advisor in general, and can open so many doors to critical relationships.
Mm.
Um, Beyond the fact that like a lot of searchers tend to engage legal counsel like too late kind of in the process, what do you think are other common like mistakes that searchers make as it relates specifically to engaging legal counsel?
I'd say a big one is really, and I'm laughing because I'm thinking back to our earlier conversation, Scott, that we had like a few weeks ago, a month ago now, where I think that often the searcher goes with a lawyer that they may know who may not have the necessary expertise. and and because M&A, buying businesses, it tends to be from a legal fee perspective somewhat more lucrative than, let's say, a new incorporation. It's for a lawyer that doesn't do this type of work, it's going to be difficult for them to say no to a potential transaction, even when they don't have that ecosystem, even though they're not familiar with the latest in M&A law in Canada. And so I think a big mistake I see often is that they default to my uncle's accountant's lawyer. It's just a personal relationship. I'm not saying don't speak to that person, but speak to that person, but also speak to someone who specializes in this area, focuses on the area, and can provide value in these other areas that I just mentioned before.
Yeah, I think it's awesome advice in general. Like, if you're seeking out professional expertise, get like specialized professional expertise, even completely different sphere. But at Venture for Canada, where we're a charity, we have like a law firm that like specializes in
Mhm.
charitable law that we engage with for our charity law questions. And it's super helpful because if you're just a general corporate lawyer, you probably don't deal with charity
Mhm.
law that often, versus if you do it 24/7, you're going to have
Mhm.
just so much more knowledge and
Yeah,
expertise. I can imagine the same relates to ETA.
and especially because I hope you don't mind me saying a little bit more about this because it's so near and dear to me. Is that for a searcher, often first time business buyers, and so the stakes are so high, right? If you think like they're putting their life savings, they might be moving across the country with their family if they have small kids, whether they're married. They're uprooting their life in many ways, and so this is a high stakes transaction that someone is doing, and so you may not get a second kick at the can if the first one doesn't go well, especially because there's personal guarantees and your life could be ruined potentially if the deal doesn't go the right way. And so, because of that, it's especially important to speak to multiple people in the marketplace and vet them and understand their experience and speak with potential references because of the stakes, because of the potential consequences with things not going well.
Totally. And I
Mm.
think it's something we're trying to spread awareness of through our Entrepreneurship Through Acquisition Academy, which is that buying a business is a really risky thing to do. I think the rise of Cody Sanchez and the different ETA influencers has sometimes made this really trendy. And I think
Yeah,
people think that it's like easy money. Like sometimes some of the ETA stuff online reminds me of like crypto, like in 2000, 15, like want to get rich with minimal work, do this. And
yeah,
to your point, it's like really, really like buying a business with a personal guarantee, and it's one of the more financially risky things that you can do. So if you're going to do it, you need to be very judicious, and
Mm,
to your point, like engage
mm,
counsel in an effective way. Out of interest, Josh, like of all the different kinds of
mm,
like law like out there to like practice and
mm.
specialize in, why did you decide to like focus on kind of entrepreneurship through acquisition and helping people learn how to buy
Oh
businesses?
yeah, I've decided to focus on it because um, I think it plays well into my skill set of being that facilitator and trying to add value beyond just like the quote unquote legal deliverables, right? Of course, that is, if you get an M&A lawyer to do your deal, they better be able to do legal documents, because if they're not, then they shouldn't be practicing that area of law. But what else can a lawyer offer beyond just the legal deliverables that can be a value add to that client? So what I mentioned before, right? Those connections, that specialized expertise, um, being able to, and that's also, it ties into my love and passion for entrepreneurship. I started my law firm from scratch, right? Zero clients, $0, zero, literally from zero. And so I have a firsthand experience with what building a business is like. And so focusing on M&A and ETA, helping first-time business buyers, um, I just feel like I understand that psychology more because I have built a law firm from nothing. That it's just a type of person that I really feel like I understand and that we can provide a lot of value to, because, um, like I said before, we treat it with the gravitas, the um, we understand what entrepreneurship really means at like a really deep skin level. Um, that and that it's been a meandering journey. It wasn't like this early on in my legal career. Part of it was really trying to figure out where exactly I was best situated, but this has just been the area that I find that really ticks off every box. Where we can be legal advisors, we can be business advisors, we can be facilitators, and like that package of what we can offer the client is really unique, and what not just me but my team and I, we really get energized helping people buy a business, scale up, and eventually sell and reap the benefits of their efforts.
It's awesome to see your passion for supporting entrepreneurs, and also that you fact you have the actual lived
Mm,
experience of founding something
mm,
your own self. I can imagine lends itself well to
mm,
having empathy for entrepreneurs in their journey.
mm,
One thing to sort of dive into a little bit is around due diligence and like the role that like a legal counsel plays in supporting the due diligence process. And for listeners, of course, like a lot of due diligence is done by like the searcher. You know, it's looking through uh, details, or it's hiring often like an accounting firm to do a quality of earnings report. Like there's a lot of things that fall outside of the scope of a lawyer, but legal advice is really important as
mm,
part of that due diligence process, from what I've heard.
mm.
So, Josh, like, what when you're engaged as part of that like due diligence, like what are some of the ways that you kind of support the process?
Yeah, so we have a full a legal due diligence checklist. You correctly identified, Scott, that there's financial due diligence. If there's a technical aspect to a business, there's technical due diligence. If you have like software, for example, or you have heavy manufacturing, you may need a manufacturing expert to speak to technical due diligence. Legal due diligence is its own list, which we prepare and we adjust based on the business and the industry, the transaction. And really, what we're trying to do is uncover all the skeletons. And I think that this is where a source of, um, I don't want to say disconnect. What word am I looking for? Lawyers have a reputation for being deal killers in many ways. If you look at like different search boards, like, oh, lawyers, we're afraid of the boogeyman, right? Like that's like the reputation that I think lawyers as a class have. But really, we're there to counterbalance, because the seller is going to present a very um, favorable view of their business. The broker is going to present a very favorable view of the business. And so the lawyer on the buyer side really is that counterbalance to the narrative that seller is experiencing from the sell side. And so we're there to uncover all the skeletons, to stress test what the seller and the broker are selling about the business, are stating about the business, and to do digging to see, okay, is what the seller is saying about customers, is that accurately reflected? So if the seller is saying that we have long-term contracts, let's just give you an example, long-term contracts with our top 10 customers, and they say that X percentage of revenue, they cannot get out of those contracts unless there's a breach. And so what the seller is saying about those contracts, now on the legal side, we're trying to confirm that. We're trying to see whether that's actually true. And if it's not entirely true, then what are the differences? And does this rise to the level of it being a risk to the transaction? So I think it's going deep on like these areas, like customers, like vendors, like employees, like rental leases, like these large areas where the seller is giving information about what those areas look like, and then from a legal perspective, we're doing the digging to see whether that lines up with what we're seeing as well.
One of the things that I've heard from people that is a big difference in ETA in Canada versus the US is the asset purchase versus share purchase.
Mm-hmm.
And in the US, asset purchases are like, I've heard like 90% of all lower middle market M&A. In Canada, it's like the flip, it's like 90% share purchases because of the capital gains rules in Canada. And obviously, when you're then doing a share purchase, you take on, like, my understanding is more of the legal liability because you're buying kind of the entity. How can like a legal counsel support a seller, or sorry, buyer, to sort of understand like that they're not buying a company that has like all these hidden lawsuits and like legal kind of issues? How do you kind of mitigate that risk?
Yeah, you're right about the characterization of U.S. versus Canada. In Canada, we favor share purchases for that reason. That's so advantageous to sellers from a tax perspective. And that's what drives deals, right? Sellers, there is a lack of quality deal flow, it seems, at all times. So sellers often dictate, and sellers want share purchases. That's what we default to. Of course, that carries, like you said, these risks that you're inheriting when you buy the shares. You're inheriting the liabilities of that business. And so we have like a multi-pronged approach, which is that there is information we can gather from public searches. So you mentioned litigation. If the seller says this business has no litigation, then we can conduct a search in the public record to make sure that's accurate. So we would do a 10-year search in the past 10 years. Tell me about what litigation has been initiated by or against X company. And you'd be surprised how often a seller says there's been no litigation, and then we do our searches and something comes up. And then, of course, the answer is always like, "Oh yeah, of course, yeah, I it slipped my mind about this piece of litigation." And then we go a bit deeper and really figure out, okay, what happened here, who is suing who, what's the quantum of damages, and what's the risk. So we do public record searches, and then we're confirming. Like I said before, those liabilities or obligations that company has entered into, for example, under contracts, we're going through the contracts to see, does this line up, right? This customer contract, you're saying that these are the terms, this is the revenue that you expect to generate. We're going in there and confirming that that's accurate. So we do all these steps to mitigate, well, to uncover and expose liabilities, as well as like we started the call off, right? There's always going to be something. There's always, no deal is perfect, and the things that do come up that aren't ideal is like, how do we build a risk mitigation strategy around that? Do we hold back part of the purchase price? Do we, in a worst case scenario, do we reduce part of the purchase price? And we try to always be flexible and adjust the transaction so that it doesn't fall apart, so that buyer and seller can get to the result that they want.
When you think of kind of pattern recognition and all the different kind of deals that you've like looked at, and all this legal due diligence, like what are common kind of surprise legal things that kind of like pop up when you're doing kind of legal due diligence?
Okay. I'd say one is, I mentioned it before, litigation. that we have not been sued. It's a very standard representation in the purchase agreement, like that main transaction document, that there's been no litigation. And so the seller makes a statement in the agreement that there is no litigation, and we search, and it turns out that there is some piece of litigation that comes up. Not often, I wouldn't say, but it's also not seldom. And then, sometimes it's an innocent mistake because it was small and it was years ago and people forget, but sometimes it was just a misrepresentation that the seller, and now then what happens is that things become eroding to the seller's credibility, because credibility is such a big aspect of transactions. So, litigation comes up that wasn't initially disclosed. Okay, now the buyer's view of the seller goes down a little bit. Another thing is employee issues. Like, again, standard representation is that there's been no employee issues. The company has no employee liabilities, disputes, claims. Like, we use very broad language to cover off any potential issue. And it turns out that there's an employee who maybe hasn't sued but has threatened to sue, and the seller wasn't upfront with that, and now we have to quantify the risk because that employee has a claim against the company. So even though the buyer is new to the business, is buying the business on a particular day, like we said before, the buyer inherits those liabilities. So an employee that has a claim against the company, the buyer would be dealing with that claim, being the owner of that business. So I would say litigation comes up, employee issues come up, customer issues come up in terms of, a big one, which has come up in the past week, has been, we include a statement that no customer has indicated an intent to terminate, because you want the seller to tell us everything about the business. And so just this past week, we were dealing with on a transaction that this line about no customer has stated their intent. And it turns out that, there was a customer who was unhappy with the service that they were getting, and they had not terminated their contract yet, but there were rumblings about it from them. And that only came out, fortunately, at close to closing. And it was not their largest customer, but a top 3 customer. And now we're, analyzing the impact of that. So I would say those litigation, employees, customers are common things that come up during transactions.
One of the things I'm amazed is that sellers actually think they can hide like the litigation. Like, it's like most people are going to do a search of the public record, and if there's like a lawsuit, I guess some sellers are kind of guessing that a buyer is just not going to do sort of the basic due diligence, and that they can just sneak kind of a secret lawsuit in.
In the lower middle market world, it really is. It kind of can be the Wild West at times. You're dealing with sellers often who are disorganized, who don't have a complete paper record. It's not always that they're trying to hide, I don't think. It's also that a lot of businesses have done well, gone to the size and scale where they're sellable, where they've generated real value. But internally, it's just not, like we're talking, there's some businesses that still run on pen and paper. And accounts receivable is a literal piece of paper that the office administrator crosses off. But those sorts of businesses represent big opportunities for buyers, because modernizing the platform, having a CRM in place, these are very low hanging fruit that a buyer can go in immediately and improve the value of the business. But what comes with that opportunity is often like this disorganization and helping. Often it's a seller's first time selling a business as well, so they may not necessarily have polished the entire business for sale, and so I think that this type of stuff, it comes up more often in our world, like the lower middle market world, because of the seller profiles that we deal with.
Yeah, totally. One area I'd love to zoom in is LOIs, or letters of it's kind of intent. Josh, for our listeners, can you first kind of give a little bit of a high level overview of like what is an LOI at a very high level,
Mm,
and then can you also kind of give a little bit of context of how lawyers can help searchers through the LOI kind of process?
sure. Like the LOI is a non-binding document that buyer and seller both sign, where they outline the key terms of the transaction. So things like purchase price, timing, whether the buyer is buying assets or shares, really high level overview of what the buyer and seller are agreeing to before deep due diligence is conducted. And then that LOI gets replaced down the line with a full purchase agreement. And the reason why we do LOIs is because we want to make sure that we have agreement on the key terms of the transaction before spending the time and money drafting a purchase agreement. Because what you don't want, and which unfortunately I've seen before, parties rush into the purchase agreement because they want to get a deal done as soon as possible, incurring those expenses. But it turns out that there was no base understanding of what the transaction was going to be. And so the LOI is like a short, under 10-page document, which outlines everything. Buyer and seller sign it. It's non-binding, so either party can walk away. I should caveat to say that sometimes there's an exclusivity clause, but other than that, you don't. The LOI does not bind the buyer or seller to buy or sell the business from a legal perspective. That comes down the line in a purchase agreement. What lawyers can do, and now I think like in the past, law, buying businesses, ETA, it's constantly evolving, right? Like you mentioned Cody Sanchez, and it just this real. It's a very dynamic area, and things are changing all the time. So in the past 5 years, I'd say 5 years ago, sellers were not drafting by default their own LOIs. I'd say that some were, but majority were not drafting their own LOIs. They were getting a lawyer to prepare the first draft, and then the buyer was adjusting the lawyer prepared LOI. I think in the past 5 years, like now, I'd say that the default is that seller prepares their own LOI using a template they find online. And so what a lawyer can do is give it a review and make sure that anything that should be in the LOI is in there. Because if you're grabbing a template from the internet or ChatGPT, it's just gonna, like, a person who's not familiar with LOIs is not going to be able to assess the completeness of that document. And the thing with LOIs is once they're signed, it's very hard to go back on them. Even though they're non-binding, it's very hard to go back on something in the LOI that was agreed to between buyer and seller. So, for example, if the buyer prepared an LOI that says $1 million on the closing date is the purchase price, it's going to be very, very difficult, unless you have a great reason, to go back and say, actually, you know what I meant was 500,000 on the closing date and 500,000 in the seller note. That's going to be viewed as a retrade of the deal, and it's not going to go over very well with the seller. So I think what a lawyer can do is give that quick review, that input, so that just to check off boxes, make sure that everything's that's supposed to be there is in there, so that it decreases the chance of having to go back and renegotiate any critical part of the LOI.
One thing I've noticed in a lot of searchers on their websites or on like the sort of little one pager overviews that they have is like this kind of part for sellers where they say like LOI within 2 weeks, like of like initial kind of like conversation. And sometimes I've thought, I'm like, is that like unrealistic? Like to the point about what you're saying, Josh, like, it takes like to really understand the value of a business, and agree to LOI terms, which can anchor the entire future negotiation. Sometimes I'm like, is 2 weeks realistic? Like I understand you kind of want to send that message that you're not like a tire kicker. So anyway, my question to you, Josh, is like what is like between like initial conversation and actually issuing like an LOI, recognizing every context is a little bit different, but like what do you think is actually the amount of time that a buyer should actually take before even considering kind of going down the LOI route?
I think definitely there's been a trend towards shorter because it's still a seller's market. But what I mean by that is that quality deals, quality businesses for sale are constantly in short supply. So you have to move quickly in order to stand out. Because if you're going to say, Scott, that I'm going to take 2 weeks for an LOI, and you have buyers saying within 5 days we're going to get an LOI, like that speed is going to be very attractive from a seller. They want to move quickly. They don't want to wait for 2 weeks and have an LOI come that's not as attractive as one that they receive up front. So I'd say that I think 2 weeks is a long time, to be honest with you. I think that we're at the point now, because everything is so electronic and emails and automated, that you could receive a CIM, go through it, and I think within 5 days, within 5 days after you receive a CIM and start that, you should be able to know, okay, is this something I might be interested in going further and issue an LOI, or is this something I should not pursue further and pass on? So I do like that. I actually haven't seen those websites that you're talking about from searchers that mention like an LOI time period, but I do like signaling, being responsive, being prompt, especially because the searchers have, because anyone can call themselves a searcher. Unfortunately, that's like the problem with that phrasing, is that there are a lot of tire kickers. There are a lot of people who sign NDAs and receive CIMs and don't actually do anything. That brokers and sellers are really becoming aware of that, and so they really want to push people who are prompt and people who are responsive. So I would say that 2 weeks to me sounds like too long a period of time, to be candid.
Yeah, I guess maybe one comment or reflection from what you're saying is, it's like, move quickly, like kind of to recap, like for the reasons you mentioned, like good deals go fast. But like maybe be on the conservative side, like don't offer the farm in your LOI, because if you're making that, like, I guess this is kind of a commentary, or kind of a thing that's going through my head, is that if you're making, the CIMs are pretty high level, right? Like they don't go into huge amount of detail. Maybe you get the financial statements, maybe you get a few additional details. But to your point, like if you're kind of I'm kind of thinking while talking, but I get that it's a competitive market. But also, if you're a buyer and you kind of make like a sort of a more aggressive or generous kind of offer off the go, and then inevitably stuff often comes up through the due diligence. I guess the question is, like, do you think that it still makes sense to make like a sort of more generous offer if you want to get access to a good deal, even if you're kind of moving quickly and maybe don't have access, like you're really just seeing the sort of metaphorical tip of the iceberg?
Yeah, it's a dance. It really is. Like that relationship between buyer and seller is a dance, and I definitely do not recommend making an offer that you intend to walk back later. I think that's a horrible move. I have seen searchers do it where they say, well, I'm just going to, since an LOI is non-binding, let me just send this in, right? Like, let me just put it out there at $4 million. I don't think the business is worth 4, and I'm going to renegotiate this later on down to 3.2 or 3.3. I think that's a bad move. I don't recommend that at all, because you torch a lot of credibility, and you may not be successful in renegotiating that down. So I'd say getting up to that like 85 to 90% confidence interval is the way to go, where like you're never going to be 100% confident, because like you said, you're seeing the top 3% of the iceberg before due diligence. So how could you ever be 100% confident? You can't. But on the other end, on the other side of things, if it's a really attractive business that that you are interested in, you have to assume that other people are also interested in it. And if that's the case, you have to be decisive and act quickly as well. So like I said, it's that tension, right? That dance. And there's going to be so many of these moments during a transaction as well, where it's not quite what you want it to be. Is it livable? Is it survivable? Okay. And it's like this like constant, like waves of the oceans, like ups and downs, right? And so I think that I don't recommend putting in an LOI just to put one in and we'll figure it out later. I don't recommend that. I also don't recommend being too slow on them either, because if it's a quality business, it's going to attract buyers, and you just don't want to lose a deal because you were not as fast as other people.
How often do searchers do like bully offers? Like kind of be like, hey, this business is overvalued. I think it's, I mean, like it might be a good business, but just like the value that the buyers, the sellers trying to get is unrealistic. So, I mean, I've heard obviously with real estate, and so I'm familiar a little bit more with bully offers, but
Yeah,
how often?
I'd say because of the dynamics of the marketplace, bully offers you see a lot from private equity. That private equity is a player who gets bully offers, and there's a lot of reasons why. They offer certainty, track record, committed capital, a lot of other reasons why private equity is successful. I don't think for searchers, I have not seen bully offers generally, and I have definitely not seen a bully offer be successful, because like I said, if it's good, brokers are going to know where the value of a business is, and they're going to have advised the seller on what that value of that business is. And so for the searcher to give a bully offer, it's so easy for the broker to cast that aside and just be like, well, look, we don't think this offer is commensurate with what the value of the business is in the marketplace, so thank you for your offer, but we're just going to set it aside. Because they've sensitized the seller to a certain value number. So I think for searchers, because it's the first time they're buying a business, there's tactics that are not open to them. And when you have a track record, when you've done a deal, other avenues open up. But in the beginning, you have to stand out in other ways. And like you said, like the searcher website, that profile of the searcher, who are they? Why should I sell my business to you over private equity? Why should I sell my business to you over the mass of people who are contacting me to sell their business? Why you? And I think that's an easy way for searchers to stand out.
Fascinating. One closing question to wrap things up is, when you share purchase agreements, or the important agreement, especially in the context of share purchases in Canada, what are some of the common kind of pitfalls that you think that searchers can make as it relates to negotiation of share purchase agreements?
I think that there's a preconceived notion that like these things are standardized and templated, and that lawyers have like libraries of like agreements that are 99% done. And so it's just like pulling something off the shelf. And really, like, the purchase agreement is the main document in a transaction. So spending the time, energy, attention to craft that in a way that balances both the buyer's interest and the seller's interest is important. And I know people want short. I know everyone wants no one wants to read 30 pages, 40 pages, 50 pages. But really, like, often a searcher tells me, look, I want to get this deal done. Draft as short a purchase agreement as possible. And I tell them, the shorter the agreement, the more favorable that's going to be to the seller. The longer the agreement, the more favorable that's going to be to you as the buyer of that business. And so it's not a tick the box strategy, like, oh, we just need to get this purchase agreement done and move on to the next thing. No, actually, that may be a document that gets revisited in litigation if things don't go the right way. And so giving it the proper time and attention, and not treating it as like just a mechanical, mechanistic task is the way to go.
Awesome. Josh, this has been a fascinating conversation, really interesting. And I recommend people check out his website if you're a searcher looking for legal advice. As we talked about, it's really important, I think, to engage experts in lower middle market acquisition if you are a mergers and acquisition, if you're actually looking to buy a business. So Josh, thanks so much for coming on the podcast to share your expertise.
Yeah, thanks so much, Scott. Appreciate it.
Thanks for listening to this episode of A New Wave of Entrepreneurship. Stay connected with us via our socials and through our email list. And be sure to subscribe to us in your favorite podcast app so you don't miss our next episode. Have feedback on today's episode? Let us know directly in the app. Thanks again for listening and for joining the new wave of entrepreneurs. Till next time.